So, remember that case that we had? It was several years back, thankfully, where this was the only time, and rightfully so, that I was able to get 100% of the marital estate. And it involved basically the husband and the father of this child being charged with and ultimately convicted of sexually assaulting that child. So we represented the wife in that particular case, and she was actually the stepmother to this child. And so we had strategically and purposely kind of delayed the trial setting for the divorce because we wanted to see what the jury was going to do to the father, because he had been charged with, I don't even remember how many counts of sexual assault of a child. And so by the time that we went in for the divorce case, he had been convicted and sentenced to, 3 separate life sentences for what he had done to this poor little girl. And so when we went into trial on the divorce case a few months later, in that particular case, the court granted Our Lady everything, 100%. And, crazily enough, the father and husband in that particular case was arguing that he should be able to receive some portion of that estate because he had to pay attorney's fees because he was going to be in prison. He didn't have any, support. He wanted money for commissary, etc. And the judge was basically like, not just no, but hell no in that particular case.
Yeah, that was a crazy case. And there were a lot of other issues we were dealing with in that case too. But for the purposes of today, we're talking about disproportionate division and how that plays into that there. Welcome to the Consultation. I'm Josh Floyd. This is Christina Jimenez. We're both attorneys at the Jimenez Law Firm. We told you last time we were going to finish up, the factors for disproportionate division. Today we're going to talk about the child custody, how that plays a role into it, along with the nature and extent of property and waste. Kind of finish up what we started, last week or whatever it was that we did it. So, in your case, I guess it was kind of a child custody. Right, was kind of the basis. So talk us through that a little bit, like how that play a role. What does that mean?
So when we're talking about disproportionate share, just kind of recap. So typically what we do or what we see in a regular, divorce where maybe people just don't like each other anymore and they decide they want to get a divorce is what we call a just and right division, okay? And so in lay people terms, we kind of look at it as a 50-50 split, right, or pretty close to it. And so every now and again, you have one of the 5 things that we've been discussing or 5 factors that will come up. And that's what the court can use to then come in and say, I'm going to do a disproportionate share. I'm going to do more than 50% to this one spouse because they've been wronged in some way, shape, or form. And so, as we were prepping for this conversation, we were actually talking about the fact that we rarely use or see child custody as a factor in disproportionate share of the estate, because that's child support, right? That's typically what the courts look at, right?
Yeah, so that's the way that the other parent would contribute would be through child support, medical support, things like that. And so it's not really necessary to use as a basis for disproportionate division most of the time.
So that the story that I told, I think, is probably like a prime example of when that argument, and obviously, we did child custody, we did fault in the breakup of the marriage. There were other factors that we also used, but child custody was a huge one in that particular case. And again, I was representing stepmom, not even bio mom. And in that particular case, the bio mom did try to come in and take the kiddo, but bio mom had some issues of her own, and so now we have stepmom who is going to be raising a kiddo that's not her own, and she was awarded sole managing conservatorship, and neither one of the parents had any access. And so I definitely think, and obviously this particular, kiddo, because of everything that had happened to her, was going to need lots of counseling, lots of therapy, lots of psychotropic meds. Like there was really deep-seated issues that we were going to have to deal with. And so Judge gave us everything that we could ask for.
Yeah, so in that case, obviously couldn't pay child support.
Right.
Right, and so this was kind of, I guess, in lieu of type of situation. But I think that it could be used in other cases as well, right? So I think that the guidelines set forth for child support, right, is based on the presumption that there will be a standard possession order, right? And so presumably the parent that is not primary, that the kids do not live with, is going to have the kids 40% of the time, right? But when you have a situation where the custodial parent or the primary parent has the kids 80% of the time or 90% of the time because supervised visits or drug issues, or in your case, criminal issues. I know there's remedies under the child support provisions where you can ask for above guideline support, but you can also request a disproportionate division based on that kind of stuff to offset, right, what is the additional expenses that person is going to incur. So I think it'll come up in situations like that too. But we don't use it a lot, right, because we would just argue argue above guideline child support.
Right.
But in your case, I think that was the only way to remedy that.
Well, and I was just kind of thinking, like, if you have some sort of disability that maybe the kiddo has, right? Or if even the other parent, and that kind of goes back into what we talked about last week, where there was that offset, right? So what if the parent, the father, has some sort of a disability, and then, the father's not going to be able to exercise the visitation, the mother's going to have child custody? Well, then he could argue for a disproportionate share of the estate based on his disability. She could argue it based on child custody, and we may end up someplace at a just and right at a 50-50 because they kind of offset one another. So, yeah, I mean, I just don't think, it's not something that I see other attorneys argue a whole lot. It's not something that we argue a whole lot. But I think it's definitely something, now that we're talking about this, that we will start doing.
Yeah, and I think, it goes back to, again, last week what we talked about is these issues get really convoluted, property issues, right? Because when you're talking about disabilities, right, that can be a basis for spousal support. And we're talking about the child custody. That could be a basis for requesting above guideline support, right? And so all these things kind of play into one another, and you use them strategically to put your client in the best position possible. So there's lots of little factors going through.
Well, and then I think that a lot of times judges are, they'll say, I'm not going to give you a disproportionate share of the estate because I'm giving you post-divorce spousal maintenance, or I'm not going to give you post-divorce spousal maintenance because I'm giving you a disproportionate share of the estate, right? I'm not going to give you a disproportionate share of the estate because you're getting conservatorship because you're going to be getting max child support from dad. Right? So all of those things are all things that we're arguing, they're arguing, the court's considering, and then ultimately, we end up hopefully someplace where the person who's winning custody is coming out ahead.
Yeah, and the things that we're talking about, like the above guideline support, post-divorce spousal, and disproportionate share, they all have different burdens, different elements that have to be met. Some are easier for a judge to order than others without having to worry about being overturned on an appellate court. And so that's kind of what we go through when we're trying to figure out how to handle it is what can we prove? What's the easiest, most effectively efficient way to do it? And sometimes based on the judge's rulings, that's the way they're ruling is I can justify this easier than I can this. So this is the way I'm going to do it. So.
Well, and also, a lot of the discussions that I have with my clients, they're business discussions, right? They're financial discussions. And so, what's the saying I always...
You screw up every saying, but give it a shot.
A bird in the hand is better than two in the bush.
That is correct.
And so, a lot of times when I'm looking at these things, and I'm looking at disproportionate share of the estate, I'm looking at, is it better, would you rather have this, $250,000 now, so that you can take that and buy you a new home, or pay off your home, or maybe invest it, or do whatever, as opposed to receiving $5,000 over the course of the next couple of years per month, right? $5,000 per month for the next couple of years. And so, those are going to be kind of the business discussions that you should be having and tax consequences and all that other stuff, which we'll typically bring in a CPA and have those conversations with them. But yeah, I think
and the bird in the hand being disproportionate division, the two in the bush being the spousal supporter.
Correct.
And they may not qualify for spousal support, right? So then you have to go to disproportionate division. And specifically here, we're talking about the way that child custody impacts the disproportionate division of the marital estate. Right. Anything else on child custody, or you move on to the nature and extent of property?
No, I mean, I feel like that's it. It's pretty...
Beat that horse, huh?
It's dead, yes. Nature and extent of property. So when does this come up? So if somebody has separate property, or if all the wife is going to get is a dead horse, right? That's not really...
The extent of the property she's receiving
is not...
very natural.
We're trying. We're gonna try. We're gonna do this. And so,
it's in nature. The dead horse is in nature.
It is in nature.
And
so if wife is getting, let's just say hypothetically speaking, the home, right? And let's say that it's just the home's maybe paid off, and it's a nice home. It's just a regular house. I'm talking multi-million estate here, but it's a regular home that she's going to need for herself and her children. And maybe she doesn't have the ability to earn a whole lot of money. And let's say that house is worth, I don't know, $150,000, and husband has $150,000 in retirement and, bank account. So cash right over there. The judge could say, listen, I'm going to give the wife this house because she needs it for the kiddos and for herself. She needs a place to live, and she's not going to be able to afford to go and get a new home because maybe she didn't have credit, she didn't have the income, etc. But husband doesn't really or shouldn't really have all this cash because wife's going to need a little bit of cash too to live off of. So I'm going to go ahead and give her maybe $50,000 from the bank account. And so that's obviously a disproportionate share of the estate, but it's because of the nature and extent of the property that the wife is receiving.
Yeah, and I think separate property is going to be the biggest time that it comes up, right? When you have someone that has acquired a bunch of assets over the course of years, right? Or even they come in with a lien on the property, right? Or some type of outstanding mortgage due on it, and you're making those payments throughout the marriage, right? And the way they do the reduction, I'm not getting all that, but it's difficult and not as valuable as the estate itself. Right, and particularly if you've done like second mortgages and things like that, throughout the marriage, you've put all this money into this other person's separate property, and then just to have the other spouse walk away because the court can't give it to them is not right. But then also, like we were talking about, I think last time we were talking about businesses, right, and how businesses are ran. So the same thing here, right? I mean, you may have a small LLC with a couple of trucks, right, and so the value of the LLC may be $100,000, but we can establish that he's going to continue going on making $100,000, $150,000, $200,000 a year, but the business evaluation doesn't show that kind of number. And so the fact that he's getting that business, right, and she's not going to be no longer benefit of that business, then I think something that the courts would look at to the nature and the extent of the property that they're receiving, because it's an ongoing type of thing for them.
Yeah. And I mean, if somebody has a separate property, let's say they have a separate property home, and then we have the marital residence, right? And maybe the spouse is fighting for the marital residence, even though they have a separate property home right down the road, the court can potentially consider that whenever they're dividing all the assets and say, listen, I'm going to give wife a little bit more, husband a little bit more, because the other spouse has this other home. They have this inheritance, right? We've had that come up before, where our client had a trust account, and her family was just like generationally wealthy, and so every month she was getting a certain stipend from this trust account, and the husband was actually requesting a disproportionate share due to the nature and extent of the property. Because his argument was, she's set, right? She has this trust account. Her family's millionaires, multimillionaires. She's going to be taken care of. I'm not. I'm going to be struggling. And so that was something that the courts can and will consider. So What else?
Well, so I don't think this is one that we use a whole lot, right? Because there's other remedies under the property stuff like reconstitution, reimbursement, all that kind of stuff.
Mm-hmm.
I don't think I use nature and extent of property a whole lot when I'm talking about disproportionate division.
So I do typically in the context of when we're looking at assets that are not liquid. Like that's when I start kind of saying, well, we need this car, we need this house, but we need some cash too, right? We got to figure out a way. And of course, obviously the counter argument is, well, sell the car, sell the house, right? But sometimes you can't do that, right? So, we had a case where our client had some pretty severe mental health issues like bipolar, schizophrenia, and she may have been able to work. I think that she probably could have eventually been able to go in and work, but it was one of these things that stress would cause, these ailments to what would you say, appear, I guess. And so she'd have
exacerbate.
Breaks. It would exacerbate.
It didn't do that.
So she would have issues, right? If she had to go in and work and do all these things. And so in that particular case, we had the marital home, which was a nice home, that had a mortgage on it that she was not going to be able to afford. And then we had this other home that was paid off, and we wanted that home, but we also needed more money. And so, because she couldn't support herself. And so in that case, disproportionate share, we got spousal, we got child support. And so, we kind of got a little bit of everything on that one.
Yeah, and continuing to talk about the nature and extent of property as it relates to one of the factors used to disproportionate division of the marital estate. So I can see it being used in a situation where like the primary asset or only asset or whatever basically would be a home, right? And so it's like a $300,000 home, but they owe $250,000 on it. So Justin Wright each get $25,000, right? $25,000. All the mortgage people are probably going to jump on here if I'm incorrect, but my understanding is you can't refinance the home if you owe more than 80%, right? Or you can only get 80% of the value on a refi. So in that situation, she would only be able to refinance for $240,000, which is not enough to pay off the mortgage and give the other spouse the $25,000. So there we could argue disproportionate division based on the way that the property is going to be handled. There's no way for her to pay that other $25,000.
Well, and then the other thing is retirement accounts, right? So if all that one of the spouses is receiving is a retirement account, and the other person, so let's say we have $250,000 in a 401k, right? And then we have the other $250,000 in cash and, maybe some sort of a residence, a vehicle, something like that.
Horses.
And horses that are living.
Living
horses. And so if all you're receiving is this retirement account, then we maybe want to argue, let's get some of this cash over to us. We want to keep all of our 401k, but we want all of this cash as well. So, or some of the cash as well. So.
Right. Yeah, and I guess you argue the penalties associated with getting the 401k, right?
So,
that's all I got on that, yeah. I think we beat that dead horse.
We have. It's now dead.
Override.
So, the last and final element is waste.
Wait, we said it was factor.
Oh,
right?
factor.
I think last time we decided it was a factor.
It's a factor.
Not an element, not a prong.
It's not a prong, for sure it's not a prong.
It's a factor.
So the last factor is waste.
The last factor of disproportionate division.
Of the estate is waste. Such a teacher's pet. So
not like garbage, right? Not like garbage waste.
Not like that, which is the profession that we've considered many a times.
I always said that's by default, garbage collector.
And so when it comes to waste, that's actually probably the one that we look into the most when we're doing disproportionate share. And so basically what waste is if you have one of the spouse that is wasting assets, wasting money, diminishing the value of property, I think would probably go under a waste claim, which I am going to be having that issue come up here pretty quickly in a case. So waste is, I think, more prevalent because when you see that, it's because somebody's having an affair, and they are spending their money on the mistress or the mister. What do you call the man that's the mistress?
Sancho?
The Sanch. So they're spending money on their Sanch, and so we go in and we prove. That was the story that you gave the last time we did this, right?
Yep.
And so basically we had a husband who was going and spending money on his mistress. They were traveling, buying nice things, etc. And we were able to get, or you were able to get the bank statements, credit card statements to show, listen, he dropped $30,000 on the mistress, and now we made a waste claim to say we need to have more money in this whole thing.
And again, as convoluted as property gets, right, there were other ways to try to reconstitute the estate and things like that. In this situation, it was easier just to make a waste claim because he had wasted, was it $30,000 or $40,000? I don't remember the number, but of the community funds, right? But yeah, it comes up a lot with adultery. So
really quickly, let me interject real quick, because that's also, it's super frustrating when you're trying to establish it, because then you have the argument of, okay, well, yes, he went to Vegas, but how do we know that he went with the mistress, right? I mean,
because they're fools and posted on Facebook. That's generally how we know.
And so, and we had that as well, like where, I think we had a picture of the new girlfriend, and she was rocking a Louis Vuitton purse. And then the girlfriend shows up and says, haha, joke's on you, it's a fake. I bought it for $30, or he bought it for $30. And so we're like, damn. And so, but
an authentication expert.
Exactly. So those are a little bit kind of wonky, like when we're going in and trying to prove this stuff up. I like to have corroborating evidence, right? So the photos of them in Vegas, the photos of them in New Mexico, the girlfriend maybe getting pissed off at the wife and saying, haha, I was just in Vegas with your husband, that sort of crap.
Or the girlfriend catching the guy cheating with someone else and then coming in testifying for us, all the things that he did for her.
Yes, queen, yes.
Gold.
So, yeah, we've had those types of situations, but it can be sometimes frustrating, right? If you don't have something like that that's taken place, I mean, all you have are expenses on a bank account.
And that's the difficult part, is it's our burden to prove the waste, right? That it wasn't used on normal spending, whatever you call it. What's it called? Normal?
Reasonable and necessary.
Yeah, living expenses, etc. Yes. So that's kind of the difficult part. And sometimes it unfortunately takes a lot of work to find this kind of stuff, going through items of bank statements and credit card statements and finding the one little nuance, like in this case, right, the one little credit card payment, right, for the statements he didn't turn over, right, but for going through all of that in such fine detail, we never found out about it. And so unfortunately, it gets expensive when you're trying to do that, because it's a lot of time going through statements and credit cards and all that kind of stuff.
Have you ever had a situation where you were defending a client, or they were on the other side, where the waste pertained to a dead horse?
Like if they intentionally killed the horse to keep the other party from being able to get the value.
We have had a case, not dead horse, but living horses that were sold. Do you want this example? The living horses were sold to another family member for they were valued at $10,000, and they were sold for $200, and so that was quite wasteful. But unfortunately, those horses were
alive.
So,
but that kind of, I guess there's more than one way to skin a cat, right? But that could be a fraud claim also, but fraud can be difficult to prove.
Right.
With all the elements. We're talking about the factor waste, right?
Right.
For disproportionate division, but there's a lot of elements in fraud which can also, not getting into that, but yeah.
So when we're talking about waste, though, it doesn't always have to mean that we're wasting it on mistresses or sanchos, right? It can be, we've seen this a lot, where all of a sudden we're giving gifts to family members, right? To the adult children or to the parents or the sisters or the brothers, right? We've had cases where the spouse has decided that they're going to go on a trip to Europe. It's something they've always wanted to do. And they are doing this during the divorce, and they spend $20,000 on a trip to Europe.
Gambling, right? When they're withdrawing the 401k,
one.
Gambling all the money. Or I've got one now involving investments in the cryptocurrency, right? We're just blowing it. So, yeah, any way that you're just taking the money and careless with it, because each spouse has a fiduciary duty to the other spouse, right, to preserve the marital estate. And so when you start breaching that fiduciary duty and wasting the assets, which results in the deprivation of the innocent spouse being able to have a claim towards it and being able to acquire it, you have a waste claim, and disproportionate division can result in that.
So when you talked about gambling,
Have a gambling problem? Oh,
I don't have a gambling problem. I actually don't care for gambling.
I hate gambling. I hate losing money. I hate losing money.
I don't care for it. I like to eat in Vegas. That's why I go to Vegas, is for the restaurants.
Withhold the joke.
Thank you, Floyd. I appreciate that. But we had a case where, man, I felt so bad for this lady. We represented the wife, and she knew that her husband gambled, right? It was really kind of a basis of the divorce, was because she was tired of dealing with that craziness. But she did not understand the extent of his gambling until we got involved. And we got his bank accounts, that he had a different account. We had our bank accounts, and we do spreadsheets. Floyd's a spreadsheet. Whatever, I don't know.
Genius? Is that the word you're looking for?
You're annoying with spreadsheets, but
no, I just get frustrated with your inability to do basic spreadsheets.
I am good at spreadsheets, and so we do spreadsheets.
Yeah.
So back to the story, to the disproportionate share of the estate,
which we need spreadsheets to prove.
And so we go through and we do a spreadsheet, and we show all of these transactions that this guy was doing on an online gambling site, and it was over $170,000 within 3 years. And this poor lady was completely, she was just heartbroken because he had wasted all of this money. And that was, I think, the net loss. So we were accounting for his winnings too when we were doing the spreadsheet, but she had lost $170,000 through her husband's gambling addiction. And so it was wasted. Yeah.
Yeah. So that guy might be dead, much like the horse. Right? Speaking of the dead horse, right?
I'm trying to think of it. No, there's more. I was going to come up with another example until you said your corny joke. So
first of all,
wasteful. You're wasting my time. Is what you're doing right now. So we had the paramours. We had the family members. Destruction of freaking property, or diminishing the value of property. I think
killing a horse.
If you killed a horse and he was dead.
If you killed a horse, could he be anything other than dead?
I had to bring in the dead word. The horse is now dead, and maybe the horse was a prize-winning horse that was valued at $10,000. And I don't know, how much are horses? Do you know?
Dead ones, not very much.
But if it had been living, and the husband, just to be ugly, decided he was going to kill it to make it dead, then that's a waste claim.
And rude.
Yes. So we have a case where
please be a dead horse.
It's case. Not. No. So the vehicle was the wife's separate property. Husband figured out about halfway into the divorce that she was going to get this truck back. And so we make arrangements for wife to pick up the truck. And this is a truck that he'd been driving for a couple of years, and it was in great condition when he was driving it. And now all of a sudden the engine is somehow busted up and it's not operable. And so we're going to have a mechanic go in and look at it. And I don't know, like maybe sugars. I suspect that it's going to be something silly. Sugar in the gas tank? Is that like
It's
how?
never a good idea.
Yeah,
It can
yeah.
destroy a motor pretty quickly.
And so I actually got him on the witness stand a few weeks ago and kind of admitted that the truck conveniently stopped working when he figured out it was her separate property. And he happens to be a mechanic. And he knows that something's wrong, and he kind of chuckled when he said it. And so when we go to a final trial on that, I suspect that we're likely going to get the value of that truck back.
Did you ask the court to note the chuckle on the record?
I did, yeah.
Awesome. That's great.
Note the chuckle, Your Honor. I think those are pretty good examples of...
And like if there's a business involved, right? You stop working the business to devalue the business.
Yeah.
Right, during the pendency of the divorce, that you know that you can just ramp back up when it's over.
And so, and like that example that I just gave, don't do that. Like, please don't do that. Because the thing that's so foolish, and I suspect that this gentleman's attorney did not have this conversation with him, but this gentleman would have been eligible for a reimbursement claim, which is a separate topic for another day. But he would have potentially received money from this asset. And now he blew it, right? Now he's going to end up owing her money for this crap. And anytime ever I have seen a situation where our client or the other client has tried to diminish the value of property, it has not gone well for them in the court. I mean, judges get pissed about it. They get really mad.
Yeah, I'm just going to go ahead and say, like, don't do any of the stuff that we've talked about in any of these videos. Right?
Yeah.
Don't have affairs. Don't waste assets. No family violence.
Right.
Don't go to prison for sexual assault.
All sound advice, I think.
Don't do any of that stuff.
Yeah.
Don't kill anything living, especially horses.
Right. Also good advice. But
so the general rule, just don't do none of this crap.
I understand. But here's the thing that we see is like people get so pissed at the divorce and the fact that it's happening and what the other spouse is doing that like this other stuff that we've mentioned, I don't know, sometimes people don't think naturally to do that, but they do think of screw him, I'm going to take all of his watches and destroy them because I know that there is prized possession.
That is rude.
Yeah.
Just kill the damn horse.
So, but just don't do it because at the end of the day, you're gonna likely get busted up for it. And
doesn't your husband have a lot of watches?
He does. So, hence my example. So, let's hope we never that never comes up.
I think she's giving herself advice at this point.
And so, I think other than that, is there anything else like on waste claims?
I don't think so. I think we've pretty well gone through all of the factors for disproportionate division and beat the dead horse for each one of them.
Yeah. So, I mean, I think...
But you don't beat a dead horse, for the record. You don't beat a dead horse.
So...
You guys do.
We beat it even after it's dead?
So, let's say, we go in and we're able to prove one of these factors or several of these factors, right? I mean, what is the judge? It's kind of simple how he divides it, but I mean, it's simple to us. It may not be simple.
He gives a disproportionate division because you've satisfied the factor for it. Generally, I mean, you're not going to get 100% unless the guy's going to prison for 3 life sentences. Generally, you're looking at a 60-40, maybe 65-35. I don't know that I've seen much above that. I've been seeing like 80-20s and stuff. A lot of people come in with unrealistic expectations, thinking, "Oh, I'm going to get everything he has because he had an affair." No, you're not. You're not. You may get more, but you're not getting all of it, and the judge is going to let you clean him out. What he did was wrong, but he still has property interest. So
it's 15 years, and for you going on 11. Only one time ever have I seen the 100% ruling, right? And that's that sexual assault case. Never heard of it from anybody else or anything like that. I've only had one judgment that was, my worst was a 60-40 split. And that was a pretty egregious situation that had happened. But most of the time, when you're looking at these factors, 55-ish is probably where you're going to be. So when I'm looking at this and I'm having these business discussions with our clients, I'm looking at the overall value of the estate, and I'm looking at, well, how much really is 5%, right? If we're talking $5,000, it may not be worth the time and the energy to go in and try to argue these elements, right? If we're talking factors, if we're talking 50 to 100,000 or, $250,000, then yeah, it's probably going to be worth the time and the energy to go in and explain your story to the court. I think it's important always that you look at these things as business decisions, and it's so hard. And it's so easy for me to sit here and say it, right? Because I'm not in it. But when you're emotional and you start to make emotional decisions, they become sometimes bad financial decisions, which is not something that you want to do, right? So we want to look at the overall value of the estate. How much are you getting? How much is the time? How much are your attorney's fees? Let's offset all that good stuff. And then let's say, yeah, this is worth fighting for this stuff and proving it.
Yeah, and even if you think that it may be, 5% isn't a lot, right? It may be difficult to get it or make it worth your while. Remember, there's a bunch of other remedies we've talked about, reconstitution, spousal support, all that kind of stuff that may be better spent going that direction. So.
But that gambling example that we talked about earlier, basically what me and the client said was, let's go through about 3 or 4 months of bank statements and let's see how bad it is. And if it's not that much, then let's just say, screw it, moving on, get the divorce done. And then when we started looking at 10,000, 20,000, okay, now this is something that we're going to really deep dive into and make sure that we get a disproportionate share of the estate.
So I think we've beat up disproportionate division. Told them everything that we know.
Not really.
Everything that you know, not certainly.
Highlights. Right. So we've touched on highlights. So as always, thank you guys for watching the consultation. I'm Christina Jimenez. This is Mr. Floyd. And we've discussed disproportionate share of the marital estate. Please make sure you follow us on all social media platforms, TikTok, Instagram, Facebook, YouTube channel, like and subscribe. And we look forward to talking to you guys next time.